So if you're convicted of something you didn't do and you don't admit to it, it doesn't mean you did it. I mean, just because you're convicted of it.
That's correct.
Any questions?
So being convicted of something is not the same thing as admitting something you actually did, now is it?
Yes, sir.
Okay. So you can be convicted of something you didn't do, right?
Yes, sir.
You can be acquitted of something you did do, right?
Yes, sir.
And there's all manner of things in between, right?
Yes, sir.
Okay. That's all the questions I got.
Anything further, Mr. Dean?
No, you're not.
Ms. Howell, you may step down. Any further witnesses, Mr. Hilliard?
I have to give my client an opportunity to allocute if she wants to, but I think that we've already discussed it. I don't think she wants to testify, Judge, but I think that you have to make that inquiry, not me. So.
Ms. Simon. Ms. Simon, we've come to the place where you have the opportunity to testify if you choose to do so. Do you understand that?
Yes, ma'am.
Do you still have the right to testify, and you also have the right not to testify? Do you understand that?
Yes, ma'am.
No one can make you testify.
Yes, ma'am.
And whether or not you testify or make a statement is solely your choice, not your attorney's choice, but your choice.
Right.
Do you also understand that if you choose to testify and you take the stand, then the state will have an opportunity to ask you questions as well?
Yes.
And you understand that we are at the point where there's evidence in aggravation and mitigation, and all of this I will consider in determining the sentence today. Do you understand that as well?
Yes, ma'am.
Ms. Simon, do you wish to testify?
No, ma'am.
Thank you. You have a seat.
And just for the record, we've discussed it, Judge, and several times, and if she has any questions, she knows she can ask me again at this point. But other than that, we're ready to move into just argument phase.
Okay. Let's move into argument then. Mr. Dean?
Your Honor, I will reserve.
If I can approach, Judge.
You certainly may.
One ministerial thing. Early in this case, before I got it, the Public Defender's Office had filed a motion to preserve notes, evidence, and things as such. For the last 2 years, we've tried to figure out why they couldn't release Quinton's remains. It seems that motion is the holdup. I spoke with Mr. Dean last week. I spoke with Ms. Simon. At this point in time, we withdraw that motion from here on out to preserve. That way the remains can go ahead and be released back to the family for appropriate burial. And whatever orders need to be put on to do that, I will get with Mr. Dean and I will do that.
Before Mr. Hilliard gets into the substance of his argument, may I respond and we can kind of bring this issue to a conclusion?
Yes.
Would that be okay?
Yeah, that's fine.
Just to clarify, this was during the period of time that the defendant was represented by previous counsel. It was Robert Attridge, Joseph Vinieri, and maybe Caitlin Walker. I believe it was Mr. Vinieri sending me an email asking me to ensure that Quinton's remains, which by that time had come down from the FBI lab in Quantico to the GBI lab in Pooler, I think. It sent me an email asking me to ensure that the remains not be released for interment, but instead retained by law enforcement in case they wanted to request any additional forensic testing. I got that email and communicated it to law enforcement and asked that they honor that, which they have. And Mr. Hilliard's right. That email is why Quinton's remains have not been released to any family members for burial. In advance of today's hearing, after the most recent of a number of requests to the family from the family that we address this issue, I sent Mr. Hilliard and Mr. Pearson an email asking whether Ms. Simon would lift what essentially functions as like a hold on Quinton's remains on the record, so that we can safely release Quinton's remains to the family for burial or cremation or whatever it is that they ultimately decide to do. Because I very much respect the request and agree that it's probably something that ought to happen. We could agree to that without being accused of spoliation or something like that later on down the line. So I'm happy to hear that they're willing to do that. If I would ask that the court inquire of Ms. Simon personally about that and confirm that she's okay with that, so that everybody can then move forward.
And I was going to get to that next, Judge. I've had the discussion with her about spoliation and to preserve the record for appeal. We had that discussion, and I'll let her answer for herself in a second. But we understand it could affect the appeal going forward, but she felt that it was more important for the family to be able to bury Quinton than to preserve any possible testing for future references. And I told her both the positives and the negatives of it. Is that correct, Leilani?
Yes, sir.
Okay, and I'll let the court engage in a colloquy about that. But we did discuss it, though, correct?
Yes.
Right?
Yes, we did.
In deciding, you've heard the discussion that's going on right now about Quinton's remains.
Yes, ma'am.
And there was a hold placed on the release of the remains in case there was any further testing that needed to be done. And that request was actually made by the attorneys who originally represented you. You understand that?
Yes, ma'am.
Okay. The release will happen, but we want to make sure that's what you would like to do. Would you like for his remains to be released to the family?
Yes. Most specifically, my brother, who's here today, Paul Simon.
Paul.
I would like him to be the one that they're released to.
Now, I don't know how logistically how that works.
I don't know. That has more to do with probate and administration, and I don't know anything about that.
So I think who they're ultimately released to is kind of not our lane. I think that's between like the GBI and the coroner and the police and all that. I think our only concern here is whether, as a result of the defense's requests to the state, they're going to continue to be prevented from being released to anybody at all, or not.
And I understand that, Mr. Dean. I understand that makes sense. So, who the remains will be released to is a matter that's beyond this court. Okay. But you agree to have the remains released.
Yes, Mr. Hillary spoke to me about it on Sunday when he found out about it. I waited until yesterday so I could think about it.
Mm-hmm.
But my son's been through enough. Your Honor, he's been through enough.
Okay. And Ms. Simon, do you have any further questions about that?
No, ma'am.
Okay.
And I would like
Mr.
to,
Hilliard.
I discussed with you that there could be further testing and science could advance in the years to come.
I know why there would be a downfall. I understand that there's still matter with the and I want my baby home. I just want him home.
All right, thank you, Ms. Simon. You may have a seat.
I wanted to clear that up. My argument's simple, Judge. We're asking for a life with parole sentence. It's only life with or life without. I understand Mr. Dean gave this long list here, but at the end of the day, she's a young lady, and life in Georgia, at least, is 35 to 40 years before your first eligibility for parole, with parole. That puts her in her late 60s, early 70s. Mid-60s to late 60s to early 70s. We understand that we're talking about the death of a 20-month-old child. But Your Honor sat through the trial, and we don't know the manner or method in which it occurred. We still don't, and that's an issue for an appeal, which will go up. The question is whether or not she's someone who should be stuck away for the rest of her life without any possibility of seeing the light of day again. And I urge to you, there's nothing about her criminal history, which is pretty much non-existent until this. There's nothing about her life which shows that she is above any redemption or rehabilitation. The people who know her best have asked the court for a life with parole sentence. So we're asking the court for that. I understand why Mr. Dean wants to do all of these fines. I get it. I understand why he wants to ask for his consecutive sentences. I get it. But to me, the ultimate question is whether it's life with or life without parole. And we think that she deserves life with parole. We think she deserves a shot at coming out again one day. Because it's not just about fashioning a sentence that punishes the crime. You have to realize